off of the Moss Act. A recently deceased Congressman John Moss, I think he's 1966 of California. And if I have one regret today, it's Tony Windsor of Mass Law Reform. I don't know if anybody's here from Mass Law Reform. A genius, he died last year. We would love to hear his testimony, but back what the folks are doing. But I just want to clear up some misconceptions. First of all, it's very important to know what the law did. With all the criticism, and much of it fair, of course. The law was a landmark law. Let's not forget that. Heretofore, every request for public record had to have a statute base. You had to prove that it was public. Otherwise, it was private. It reversed the presumption, as did the Moss Act. Everything was public unless it was specifically exempted. Now, one of the exemptions is by statute. I think it might be exemption B. I don't have the law with me. So there's other statutes that exempt. But basically, let's always be clear, we're talking about modernizing the Massachusetts Freedom of Information Act. There are a great lot of sponsors. The Boston Globe was chief among them. This actually started, and we still are proud with it, with police departments. The Weston Town Crier versus the chief of police of Weston. And ironically, the editor of that paper, Tom Sleeper, who advocated that law, became my editor in Brookline and wrote a lot of stuff about it. What you're up against, and you guys know this, you're up against the human tendency for people to think their records are their own personal possession. They're not evil, but they're theirs. And let me tell you, some of the biggest problems was with the authorities. I heard people talking about them today. They have powerful lobbyists up here. In fact, former representative, and I succeeded him, future Governor Dukakis sponsored bills in the late 60s to make public records available at authorities, but also sponsored a version of this act, sponsored by a constituent of mine named Jerry Oppenheim. It was taken over by me in 1971 to show you how hard it is for you folks. We went through the whole session. Great support from this committee. Representative Jack McGlynn, who's my colleague, the father of the present Mayor Mike McGlynn, a colleague of mine. George Sacco, Joe Early, a future congressman, great supporters. Didn't go through. 72. And that's why I've never been a believer in short sessions as a reform. Late June, it gets to the Senate. Senate President Harrington, Senate Ways and Means Chairman Jimmy Kelly, huge supporters. It died because we were all, the delegates like myself, were on a plane July 10th, Sunday morning, to the Miami Beach Convention. It passed at the end of 73. It's tough to do. I wish you guys well to do this. But let me say one other thing. This stuff about we purposely exempted the legislature, that's myth. Public records laws always were laws about executives. Now, it doesn't mean that we can't do more. But in the 3 years, there was no testimony on improving, covering the legislature. Now, people like a victory train. Governor Sargent actually amended the bill in November 73 to cover the legislature. It was a campaign ploy. He was running for governor. He never responsored in 74. There was no lobby for it. We had to kill the amendment. We had to be the bad guys because it would have tied up, would have died again. And the lobbyists, for many people out there, the authorities would have been very happy. So I really want to congratulate you people, and I want to wish you success. But the Freedom of Information Act was a good landmark law. There's problems with attorney's fees, search records. Bill Galvin laid it out. He did a marvelous job on the thing. So that's what I want to conclude. You folks have a monumental task. I wish I was still here. I would have sponsored some of these bills and would have fought side by side with you. I left in 1999 on my own free will. But it's one of the most important things any legislature can do is to talk about the access of the public and the media to the records we hold that we either create or receive. It's a fundamental part of government. And while open media laws are generally what's called the sunshine laws, a good Freedom of Information Act is a sunshine law. So I want to thank you for listening, and again, I wish you the best of luck in doing your job.
Thank you. Any members of the committee have any questions? Thank you
very much.
Next, I'd like to call up the panel of Christian Myron of Mayoral, Ben Wright of Progressive Massachusetts, Arlene Isaacson, Massey and Lisbon Political Caucus, and Sheila Ecker, Jewish Alliance for Law and Social Action.
For the record, my name is Arlene Isaacson. I was going to testify that in part with one hat wearing as a Massachusetts as a political caucus co-chair, but again, in the interest of time, I'm going to have to end my testimony instead and talk about a different hat that I wear in life, which was helping some many environmental organizations for several years now. Some of whom I spoke with over the weekend when they started, and don't forget to tell them how many times we have put in information requests to the state, whether it was DPH or DPT, not been given the information and had to go to the EPA and get it there. Frequently because the EPA was on their website. So I'm going to cut to the chase given the time and simply say this, that while the environmental organizations request similar information from some of the stories you've heard today so far, there is one critical difference that I think is worth noting, which is that the information requested by environmental organizations affects the health and well-being, oftentimes, of every single person in the Commonwealth, potentially, if not literally. Questions like, is my water supply being polluted by a nearby facility? So does the state know about it? Are there dangerous chemicals being spewed into the air? Are contaminants leaking into our groundwater? Now, these are fundamental and reasonable questions which every citizen has a right to have information about. Yet the agencies that provide the data try to do for today prohibitively high amounts of money for them, and many environmental groups simply, as public interest organizations, they can't afford it. The burden is too high, oftentimes insurmountably high. For environmental organizations, the forms in these bills, House 2772 and Senate 1676, are particularly important when addressing the waiver of the fees for public interest groups. It's critical to that and their ability to help the safety of residents. If the groundwater in any of your backyards and the water that your family depended on was contaminated, you would want to know that. And it shouldn't cost you an arm and a leg to find it out. So we hope we'll pass these important laws.
I'm Sheila Dechter. I'm the Executive Director of JALSA, Jewish Alliance for Law and Social Action. We are a civil rights group committed to ensuring that the rule of law is a tool for justice. And how that particularly pertains today has to do with amicus briefs. I'm sure most of the members of this panel are familiar with the way in which amicus briefs are prepared and submitted. It stands for Friend of the Court Brief. And they come from organizations that feel that the court ought to know that the particular case before them has additional impact for society at large or a large group of people. So we, as a harness the pro bono support of lawyers who are our volunteer members, and they come and they will help us do these briefs. On numerous occasions, we feel that in order to be this kind of friend of the court, we ought to be providing solid figures, solid facts and figures that we can gather in a given case. And I can tell you that in countless cases we have submitted Freedom of Information Act requests, and then the amount of money that we would need to pay is even more than the printing costs of the brief, even more than whatever it's going to cost us because we've harnessed so much volunteer talent. So I would urgently ask you to think about that. For example, and I'm talking about public records. Some years ago, we were involved in a case dealing with Jehovah's Witness who worked for the MBTA. He had asked for Friday night and Saturday nights off, was willing to work on Sundays. And they said, no, it's not our policy to allow people to shift among themselves, to swap time schedules. Well, it turns out that that was a very common thing going on, but when we asked for a better handle on the records, the cost of trying to get that was prohibitive. Most recently, we did the Lucas case dealing with the discretion of police on the issue of gun violences. You're probably aware that was successful. The police are allowed to use discretion. The particular case at risk dealt with a domestic violence issue. The guy was alleged to have thrown his wife from a moving vehicle, which wasn't being challenged, but he was challenging the fact that the local police chief denied his right to a license. We were trying to get as much facts and figures available for our brief on finding out how much domestic violence played a role often in these cases, and it was impossible to get answers quickly enough, even though the statutes do allow many of these records are public records. So I want to indicate that particularly in the area of amicus briefs, that it is really important to have this protection. These bills at large, Senate 1676 and H2772, solve these problems. They appoint public records officers who will be responsible for the prompt delivery of all requests, with consequences for noncompliance and the cap costs, so that those of us in the nonprofit community trying to seek these for justice and not for profit will be able to do this. We thank you for your time and patience today. We respectfully encourage you to give this bill a favorable report.
Madam Chairwoman, Mr. Chairman, members of the committee, thank you for the opportunity to testify in front of you this afternoon. My name is Christian Meyer. I'm the political director of Neighborhood for Choice Massachusetts. We're a statewide grassroots organization with more than 20,000 members and activists throughout the Commonwealth dedicated to promoting access to reproductive justice. I sit here today in support of Senate 1676 and House 2772, and I'll my remarks in brief here in full in front of you. In addition to all of the important reasons to support this legislation we've already heard about today, this legislation also has the ability to impact the accessibility of reproductive health services. A surge of new hospital mergers and acquisitions is taking place across the country, and the state is often involved in and often playing a very critical role in certain elements of negotiations related to these mergers. The public's ability to easily access public information related to the state's involvement in this process is of critical importance. When one of the hospitals or health systems is religiously sponsored, conflicts can arise over what ethical policies will prevail in the merged entity. The most serious conflicts can occur when one of the merging hospitals or health systems is Catholic sponsored. Catholic hospitals follow a set of ethical guidelines that prohibit the provision of abortions, contraception, tubal ligation, vasectomies, and infertility services. When secular hospitals merge with religiously sponsored hospitals and agree to adopt religious restrictions, patients can suddenly discover they have lost access to vital reproductive health care services. As the potential for hospital mergers remains a constant, the public has a vested interest in the role the state plays in such negotiations, as any resulting merger could have significant and long-lasting impact on access to reproductive health care. This legislation will establish long-overdue standards of transparency and accountability of governmental agencies as it relates to access to public records. This level of transparency is an essential component necessary to guaranteeing every woman has access to the health care services she needs. So thank you for your time today.
Is there one more for the panel to testify? All right, thank you for testifying. Does any members of the committee have any questions? There being none. I'd also like to recognize Senate Vice Chair, Senator Eldridge, who's joined us. Senator, do you want to testify anyone?
No, I just wanted, if I could just reflect on the record my support for Senate 1633, Senate 1638, and Senate 1636, which were the public access records I know two of you have been involved with. Thank you.
Thank you, Senator. We have about 35 more people to testify, so I'm going to ask if everyone could keep your testimony to about 2 minutes. If you could just kind of consolidate your thoughts, we would appreciate it. Of course, we welcome your written testimony as well. Next up is Monica Lawton, the Associated Subcontractors of Massachusetts. Is Monica here? Next, Alana Richardson from Citizens of Mass.
Mr. Chairman, committee, I very much appreciate being here because it's very rare that just a private citizen pretty much gets to have a voice in a decision-making process that affects all constituents. I just want to briefly highlight a significant underlying matter that I would very much like you to consider as you are navigating the issues related to better accessibility and transparency of public records. The lack of transparency and access to public records is actually a secondary symptom to the scourge of favoritism and corruption in government offices and the courts, all the way to the Supreme Judicial Court of Massachusetts, where records are not properly processed and records are doctored according to the personal and special interests of those that are handling those public documents. sometimes an entire file is declared, quote unquote, inexplicably missing. This has actually happened to me. Where the threat of investigation is imminent. And it was in fact dealing with this file that it became evident that the reason it was declared missing was because the documents had been so severely doctored. Hence the obstruction of access to documents. Really, before access to documents and to proper access and greater transparency can be addressed, it is really important to have some kind of enforceable rules as to how documents are to be recorded and kept in public offices and the courts, whether they are electronic or belonging to the physical file, and how those files are to maintain parallel rather than as according to personal preferences of those filing. Clearing the way to reasonable transparency has to therefore be a two-pronged endeavor with fighting the systemic corruption that is so prevalent in the state of Massachusetts and that affects the moral fabric of our society and our daily lives. So again, thank you very much.
Thank you for your testimony. Are there any questions from any members of the committee? Hearing none, thank you. Next, we do have another panel. Joyce Tomaselli. I'm sorry, can you introduce Joyce?
Because of the town of Salisbury and their failure to disclose public records, they actually claimed that an $18 million, 100% fully funded EPA and state grant funded sewer project. Under oath, they claimed it was $80 million, with 90% from EPA and the state. EPA and the state has backed us up, but we've been trying to get public records from the town of Salisbury. We have lost our restaurant, Nigerian Cafe restaurant. We lost our livelihood. I lost all my savings. The town's taking my home. I'm in foreclosure to the land court, all because of public records. And the sad thing about this is we are appealing the land court. We went to federal court and the town continued with their $80 million lie to Judge Saris. So now we're dealing with corruption, the town of Salisbury, Copeland and Page, assisting them, Attorney Thomas McEnany, lying to court. However, we knew the truth from the EPA and the state. We actually asked for public records for years. We went as far as when we spoke publicly. The town of Salisbury had the police take my sister and I out of a public meeting because we were questioning. So these public records are very, very important public records because it cost me my entire life saving, my home, my business, and my life. And now the Secretary of State, I have to say thank God for him. He started to really help us because our story was so far-fetched. I think no one believed it. But thanks to the Boston Globe, Kevin Cullen wrote a great story about us, about the two sisters, prepare another course and fight for restaurants. Tom Duggan from the Valley Patriot broke the $8 million lie, and if it were not for him and Boston Globe, nobody else really believed the story. But now Secretary of State Galvin has actually helped us. Well, there was no $80 million project. There was no $72 million. And there was nothing in grants. And they have no records. And we just got a letter Friday from Neil Harrington, the town manager. They have no records of anything. So now, what do? We actually went to the federal court. They lied to the federal court. We went to the First Circuit Court of Appeals. And we are right now in the United States Supreme Court because the Massachusetts First Circuit said that we didn't find out about the fraud quick enough. Well, we've been struggling for almost 20 years. We lost our restaurant in 1994. No one has worked harder than us. And they had lied because they know that they can just say, now they're saying, I have no records. We just got the letter Friday. What do when they say they have no records for an $18 million sewer project that was 100% grant funded? And we have EPA and state and USDA documentation to prove it. We need something in the law that says not only is the public record, it has to be accurate. They redacted all the parts that were pertinent. We have to have a lot more strict guidelines here. We cannot let corruption be prevalent. We are as Americans, we're as average American senior citizens now, and you're going to find, and we lost everything because of what? Because of corruption in the state, and they can laugh about it in the courts. This is a mockery. We filed a petition for writ of certiorari pro se to the United States Supreme Court. I don't wish that on my worst enemy, or maybe I do. But we had to go forward. We are looking for an amicus brief. We are looking for help from you to stop this travesty in our state, our beautiful state, the American dream that turned into a nightmare. I thank you so much for your time, and I really hope you can fix this while I still have something to say. Thank you.
My name is Joyce Thomaselli, and we're supporting bill number 1700. And as Grace Marie mentioned, we've gone to court because of what the town has done. We have lost everything so far: our home, business property, my livelihood, all our income, her income. But it's important for people to know, to understand that you don't understand the importance, people do not understand the importance of public records that you desperately need until you are denied your access to the public records. We asked the town a simple request because the town claimed that we were the assessed owners of property at all relevant times. The town voted to construct a sewer. We bought property in 1991. We knew that the project was completed before 1989, yet the town claimed that this assessment order was 1992. It was illogical, it was impossible. So we asked the town, a simple request we made: what was the vote to construct a sewer that was completed before we bought our property? You would think that a municipality would just provide permit record. But this is not how we work in real life. We were denied this record, and with the help of the Secretary of State, after we lost the next court so far, as Rich said, the town provided to us in March of 2015. First, they redacted the vote after we told them it was the May 17, 1982 town vote. We received that from the United States EPA. The town denied it. When Secretary of Galvin gave the town pressure to give an order to give us a vote, the town redacted the vote. They removed all of the relevant information from the vote using dots. Again, the Secretary of State ordered the town, and they did provide in the May 17, 1982 vote. However, the fact is, we lost our home so far because the town is failing to provide us with public records. So, we realized there's only one reason why public records are not provided to the public, and it enables a public agency to conceal the truth. frustration, we said, court said that we should have found out the truth earlier, but it's not possible to find out public records when the town holds public records, and you have no access to the public records. They wouldn't even allow us to look to the box of the public records. Another time, they just demanded hundreds and hundreds of dollars for our request. So, the bottom line is, we could lose because of those reasons. We went to the court for justice. We needed the government records. The town of Salisbury withheld them. And the town of Salisbury's attorney told us one day, when we were leaving the court, because they won in the court, he laughed at us. He sneaked, he said, we told you that the town would do anything we wanted to do. And we walked out the door. It's as simple as that. When you don't have public records, you can't win. Courts want proof. You can't get the proof, even though a municipality gives logical, irrelevant document. My experience is just to lose everything in court. I'd like to thank you for your consideration for this most important matter. You have no idea, you've lost everything, and you're fighting public corruption. And towns that lie and they laugh about it because they know that they're protected and you're not. I want to thank you. I want to thank Diana Desario, Senator Kathleen O'Connor Harris, and Linda Dean Campbell for proposing this bill, Senate Bill 1700, the amendment. Thank you.
Thank you very much.
Thank you.
Just wait here. I'm Janet Aldrich, and the reason I'm here with them is because I have a project, a media project called the Coalition to Preserve the Public Record, and members of this group come to the State House and they capture one public hearing every year. So that, in order to become a member of it, and then that will go into a public library, an online library. So I've been here covering public hearings now. I've covered over 500 public hearings. I've offered to give my public hearings to the library, and they said I didn't have standing. When I gave one a copy of them, just raw footage of every one of them to the chair of every committee, every single time I did a public hearing. Now I'm just comfortable controlling just putting this on YouTube. But I want to thank all the press that showed up here today, I just want to put you guys on the carpet right now because I want to know White House Broadcast, who's not in here today, videotaping a public record, public meeting. So, this is one of the, things that I'm trying to address. So, this is really, really important. Because when I come to the State House, I'm going to know where's the public record, and if you're going to conduct public business, there needs to be a public record. So you're not providing the public with a public record of any of these hearings, and it's not fair. So that's what my discovery has been, and so I'm pursuing getting the State House under the public record law as fast as possible. Thank you very much.
Thank you for your testimony. Any members of the committee would like to ask some questions? There being none, thank you for your testimony.
Thank you very much. Thank you.
Next, we'd like to call upon Alice Armfield to restore the board.
Hi, thank you for allowing me to testify. I'm National Chair of Restore the Board, which is a civil liberties Fourth Amendment organization. We are attending this today because we feel that this is an enormously important issue for the Commonwealth, and to share with you very briefly the public records fight that we had and why that concept, the importance of it. Our concern was with dislodging public information from the Fusion Center in Massachusetts, the Boston Regional Intelligence Center, and the Commonwealth Fusion Center. And we had a relatively smooth process with the Commonwealth Fusion Center. When it came to the one in Boston, we had one element. After 10 months and after 2 appeals to the Secretary of State's office and after $600, we were able to receive a fully redacted document that did not contain any classified or sensitive information, and that really indicated things like whether the Fusion Center had a privacy policy. We noticed that though redacted did not contain any sensitive information, because, as it happens, the Fusion Center in Colorado had taken a different approach and had placed an identically formatted report on the state of Colorado's website. Through that, we were able to unredact all of the material that was sent to us by the Boston Regional Intelligence Center. I mention this because clearly they had wasted an enormous amount of time, not only in supplies of markers to redact material that did not need to be redacted, but they had also spent 10 minutes and had used the resources of the Secretary of State's office in coming to our defense on this. They had misused the resources of the Fusion Center in fighting this, and there was no need for it. It was wasteful. What we were asking for was trivial. And so it points up that there is a culture of secrecy at certain agencies in the state, that there is no need for it, and that reform is desperately needed. We had $600 to spend on this fight. Normal private citizens wouldn't have that. But just as a final point, this was actually the single most successful public records request that, to our knowledge, has ever been made to the Boston Regional Intelligence Center. The most successful one, and it took 10 months and 2 appeals. That is the state of the law here in Massachusetts today, and that points up the importance of the work that you are doing here today, so I thank you for that.
Thank you. Any questions from members of the committee? If not, thank you for your testimony. I'd like to just remind everyone going forward, we still have quite a few people who would like to testify, so keep your testimony to 2 minutes. That would be much appreciated. Next, we have Barbara Athens and Miriam Brogan from the Massachusetts Genealogical Council. Again, I'm sorry if I'm mispronouncing your last name.
We appreciate the fact that the committee has stayed so long for this session, and we really do appreciate it listening to our testimony. We're here to talk about 2 different bills that we talked about previously, Senate 1629 and 1630. We do have written testimony on that, so we'll be brief. My name is Marianne Brogan, I'm the president of the Massachusetts Genealogical Council. My colleague is Barbara Matthews, who's our director of civil records. So I'm going to ask Barbara to start because she's talking about Senate 1629.
Senate 1629 would open records of the Commonwealth of Massachusetts archives that are older than 90 years. And these would include, for example, the records of the Salem witchcraft trials. 30 years ago, when I first moved to Massachusetts, I saw those records on display at the library here in the State House. I looked at the page, the very page on which someone had recorded when the young women at the witchcraft trial said that Tabitha was making their skin feel like they had needles in it. It was a very moving time for me to realize, with hundreds of years of knowledge on that, what that situation had been like back then. Those records are closed now. They're closed now for overly zealous interpretation of the HIPAA laws. And we're not the only people petitioning that these records older than 90 years be open. Secretary William Galvin is also petitioning that with bill not on the issue today, House Bill 2820. So I have written testimony on this in a fact sheet, and I won't take up any more of your time.
Thank you, Barbara. The other bill, 1630, is to create legislation that would allow for non-certified copies are made of birth, marriage, and death records. Those are known as vital records in Massachusetts. Right now, the law only allows for certified copies. You've all seen those. That's what you need to get when you get a passport. They're on special safety paper. They have a gold seal and imprint, and the signature of the records custodian states their exact copy of the record on file. Researchers, historians, genealogists, medical researchers don't need a certified copy to get the records that they want to have to see these records. All they need is a photocopy of the originals. What I'm giving you in your packet is a sample of what such a document would look like. It's a simple photocopy of a death certificate with the words imprinted across, not for use as evidence in court. 17 states already do this, so we know that it's important elsewhere. Not only does it allow for less work on the part of the cities and towns and the clerks in the state office and local towns, because it would just be simply photocopying a document onto a paper that already had this pre-printed message. It would cost less for them, it would cost less for us, but it also means that there are fewer certified copies of documents floating around, because most people do not need a certified copy. Although researchers have said that who are specialized in identity theft are really convinced that the availability of certified copies of vital records has nothing to do with identity theft. There are some people who are concerned about that, and there are actually several bills that are issued every year which would close all access to vital records because of identity theft. If that information was available in a non-certified copy, then that issue could be dealt with in another way. We really feel it's very important in Massachusetts. We've been talking about public records access all day. Public records have been state would start and codify their access of citizens to records. It's actually codified in 1641. And I've given you the citation in your handout that all records are available to be viewed, transcribed, and the person can receive a copy of their request. There's no limitation in a very long history of open records. The problem is, I think, that it hasn't been completely enforced. We want to thank you very much for listening to us talk, and I hope you will vote very quickly on this bill and forward to me. Thank you very much.
Thank you. Do any members of the committee have any questions for this panel? Seeing none, thank you for your testimony.
Thank you.
Move on to Mary Connaughton from the Pioneer Institute. Doug Fraser from Cape Cod Times.
I think Secretary Galvin spoke about the importance of a point person that we go to. My specific instance that I'm going to talk about is just related to a drunk driving incident, which an officer was off duty, stopped by a state trooper let him go. The state police did respond within the 10 days to my request for the IA report and all other materials associated with the stop. But it took me years to get the actual IA report, and when I got it, it looked a lot like that. All testimony redacted from all the officers, and the officers' actual hometown of Orleans pretty much gave us everything, all testimony from all witnesses. So I couldn't see how the law worked like that. But even worse was the fact that the state police didn't feel the need to respond. They took, I think I went almost a whole year without any response to repeated emails, voicemails, even written, correspondence. So my feeling was I had no one to go to. The colonel or whatever was in charge of state police, no email address, no phone number. I was constantly thrown back on a PR person who was always not returning calls. So I think having a point person who you'd be able to go to when you're beyond that 10-day window and they're still stalling for years would be helpful to media people and others, I would think. So I think this was an important case because It showed that professional courtesy was pretty casually extended, and I don't think the average person would want to think that there was one set of laws for the police and one set of laws for the people who were being prosecuted quite diligently for OUL. So,
Thank you. Thank you. Any questions on the panel? Ms. Chairman.
Thanks, Madam Chair. At what point does the Corey law, at what point is it triggered within the investigatory and arrest process?
I don't really know the answer to that. I was basically following the line of public records because I followed for other cases where you ask, and I did in the case of the officer himself, the officer who was guilty of drunk driving. At a certain point, let's say in July of 2012, the trooper pled guilty to, the charges, But the reality was that I wasn't notified, and at the same time, they just were not answering any calls. This is the channel I was told to pursue. The only time I got an answer was when I went to the governor's office, and I gave him the timeline, I gave him some articles, and then I got a response from the state police, but it didn't help. It still took over a year to get materials that I had requested 2 years before. So it's a process that is hard for me to figure out, and I do it fairly often. I can't imagine the general public would have much success.
Any other questions? Anyone, thank you for your testimony. Next, we have William Vernon from the National Federation of Independent Business. John, is he here? Okay. Next is Dr. Ronnie Padmanabhan. Next is Catherine Rollins and Kevin Batt, Mass Municipal Association and Mass Municipal Lawyers Association.
Good afternoon, Madam Chairwoman, Mr. Chairman. Thank you very much for allowing us to be here, and we'll be brief and understand that we're standing in the so we really do quick submitted our testimony. But we do appreciate that it's important to update the public records law on a periodic basis to reflect changes in the nature of public records, privacy concerns and laws, advances in technology, the evolution of government and business practices, and the need of citizens for good and timely public information. However, we're not supportive of the bills before the committee today as written because we don't believe that they achieve these goals in a balanced way. Generally, these measures would impose burdensome requirements on cities, towns, and local taxpayers that cannot reasonably be met except for the most simple request for records. We think that they might severely limit the ability of local government to pay for the real and unavoidable costs of providing some records, and would impose unwarranted penalties on local officials. Instead, we're respectfully requesting that the committee reports out a bill that would establish a special commission charged with reviewing the public records law and how the law is administered at the state and local level. We suggest that the commission include all parties of interest, including the Mass Municipal Association, and that it be given a broad scale of authority to consider all matters related to public records, including those related to the protection of privacy and how the evolution of technology is likely to change the nature of records. I will give you one anecdote that I think might be helpful to you. Previously, I had worked for a mayor for 6 years, and one day we got a public records request that is memorable because it came from the Koch brothers, who have an interest in the wind industry. So I managed the mayor's email, and I spent probably 4 to 5 hours one day going through every email that he had ever sent or received, looking for anything mentioning the word wind. This is complicated by the fact that some of the email was searchable on the server, some had been downloaded to a hard drive years previously on a separate computer. Our scheduler spent significant time looking through all of his online meeting records and determining what records she should turn over as they related to wind. Our receptionist spent a few hours looking at records that had been in hard copy and moved to the attic of City Hall and making sure that we're in compliance on that angle. Lastly, the mayor was a prolific note taker during meetings, so we went through several of those marble composition books you might associate with middle school, reading through all of his scrawled notes and trying to figure out if any of those notes were relevant. So I tell you this only to illustrate that these records requests can be very
time consuming, they can be complex. They also involve our IT director, our assistant city solicitor, our city solicitor. We're lucky in that we have an in-house counsel to review this. Many municipalities may not and may need to rely on outside counsel. And we're also lucky that many of the records were in fact online. Some municipalities, as you know, don't have access to internet, normally at town hall, but in their municipality in general. So we ask that a special commission be created to examine all of these issues. Thank you.
Chair Lovely, Chair Koka, and the honorable members of this committee. My name is Kevin Bott. I'm a municipal lawyer. I serve on the executive board of the Mass Municipal Lawyers Association. I'm joined here by Jim Lamke, who's the executive director of that organization. In my practice, I provide town council services to 7 or 8 towns and 1 or 2 small cities. I'm very familiar with public records requests. And I come here perhaps as the only voice along with my panelists that are speaking on behalf of the custodians. We are seeking to further regulate, perhaps penalize. And I wish my testimony had been more timely with many more than people here to hear the point of view of the custodians. First of all, who are the custodians at the town level? I'm not speaking about state agencies. They are the 3 to 9 members of 9, in the case of the town of Lexington, 98 committees, subcommittees, boards, and commissions who volunteer their time to help develop policy, to help the executive officials create policy, and in many cases they have statutory responsibilities. They are sometimes also the town employees, the DPW guy that's out on the roads taking snapshots on the cell phone of the potholes. He has a record then that he is custodian of. This proposed bills that you're looking at reach to all of those people, and I would hope that nothing that you do would discourage the kind of participation that, frankly, the volunteers, particularly on those town boards and committees, are the ones that keep town meeting accountable. Not to throw stones at the idea of sunshine, but the occasional media coverage and the occasional individual watchdog that looks for public records. The 500 or so people that participate in government, of the people and by the people, are the ones that keep towns accountable, not to mention the folks that go to the traditional New England town meeting. So when we speak of custodians, I want you to keep those folks in mind because these laws reach those folks. And I would have to say in my experience, unlike what you've heard today, every employee that I've worked with does their best to comply with the public records law, timely, with little expense as best they can, with the open meeting law and all the other laws that prescribe what they should do as public employees and public officials. They do not scoff at the law. However, the idea that to search and retrieve, and also particularly speak to the proposals here to prohibit collection of costs for record retrieval, record search, record review, and redaction. I want to remind you that, ask any librarian, the idea that there's no cost to storing, cataloging, classifying, retrieving information is simply not the case. Now, if you go into a library and you ask for a copy of Gone with the Wind, well, sure, the librarian will be able to get it to you quite quickly. If you ask for all the books relating to the Civil War and the history of the United States since, if she doesn't refer you to one of our higher institutions of learning here for a course, she is going, or he is going to have a much more difficult time complying with that request. Let me give you an example from my practice. We had one request come in from an individual that wanted all the email records of 14 senior department heads and public officials in one of the towns from a period of 18 months prior to the date of the request. We asked, well, is there any particular subject matter or content you're looking for? No, I want all the records. The supervisor said, all of the records. Well, that's a reasonably specific request. You know the universe of records that you're supposed to hand over. However, at an estimate of what the number of records were, 75,000 emails. Although the gentleman that was here could perhaps give us technical ways to go through and review those emails to make sure that there weren't confidential and private pieces of information in those emails. We certainly didn't have access to that technology at the time, and I doubt many of the 351 towns will for some time in the future. So it was not optional for us to decide to just release them in a disk as the individual wanted. We had to look. It was not an option to ignore if those emails had health care information. That's protected by federal and state law. Student identifying information, that's protected by federal and state law. Social security numbers for employees, their telephone numbers, personal contact information, family information that may have come to the town manager as a result of one of their emails. The kind of breadth of that request is what we are trying to deal with. And those are the cases that come to me as a lawyer. There's no limiting factor. In fact, a requester could paralyze small government offices by simply saying, we want to look at every record you have, including those cell phone records of the guys out in the streets. The other kind of example that I want to bring to your attention, and it was alluded to perhaps by Catherine, is when towns are in litigation. Recently, there was a major case that one of my towns has in federal court. After delivering through document production hundreds of thousands of pages of records, the multinational corporation that we're seeking to recover certain environmental contamination costs for decided that they would impose successive public records request acts that had literally nothing to do with the case. They wanted us to go back 10 years for legal invoices that had nothing to do with the case, and impose burdens and pain, which is, of course, a typical tactic of litigators for wealthy companies, to try to make the town back down by using the Public Records Act as a way around what are the legitimate balancing rules in court that limit the kinds of burdens, at least without paying for them, that any side can impose on the other. And the only way that we have to defend against those sorts of abuses of public record law is to be able to charge at least and not have taxpayers bear the cost of searching, and yes, reviewing those records to make sure that there aren't any mandatory exclusions. We had to look for attorney-client privilege, which is not something that we can easily waive in the context of litigation. And so these are the kinds of issues that we are very concerned with if, number one, you prohibit collection of costs for the broad, voluminous, repetitive record requests that amount to harassment. And number two, if you penalize the folks that do their best to comply with these laws, that, of those 98 town committees that are formally recognized, we do the best we can in that town's case to provide administrative support, but certainly we can't any more than the major boards and commissions. And we certainly can't even provide public email addresses to all of them. So many of those folks, custodians of public records, are in fact using their private emails and have to worry about sorting them through. That is the price they pay for volunteering for public participation in government. But the idea that what you've heard from all of the testimony across the board, I would just like to offer some balance to that from my experience.
Thank you. Good afternoon, members of the committee. I'll be very brief. I have no comments of my fellow panelists. My name is Jim Lampy. I'm Executive Director of the Massachusetts Municipal Lawyers Association, and I am an active municipal attorney representing this town council, one town special council, several other communities. I think everyone recognizes that after so many years, laws should be reviewed periodically, and the public records law is probably due for a review. And many of these proposals that have been placed before you are well-intentioned, but unless everything is reviewed in the total context of what is the process now, what will these laws accomplish, what problems will they solve, what problems will they create. It will be very difficult for appropriate laws to be enacted. And as was suggested by Catherine, we strongly recommend that all these laws be referred to a special study commission for an appropriate review with representatives of the proponents of these laws, the other stakeholders, the Town Clerks Association, the MMA, municipal attorneys groups, other stakeholders who have to deal day in and day out with the public records. So, 2 points I wanted to make. My experience is most public records requests are complied with promptly, efficiently, and usually without a charge. Typical situation, someone comes in, they want to see minutes of a meeting, they want to see an application file, they want to see some